Good evening, everyone. My name is Faridun, and today I'll be presenting dispute resolution policy and procedures. The purpose of policy and procedure guidelines and why it is necessary. The purpose of policy and procedure guidelines are to ensure fairness and efficient resolution for disputes. The policy and procedure guidelines provide a structured approach to address disputes, promoting harmless work environment in line with organization goals and values with all industries. Policy and procedure guidelines are there to protect the right of workers. What the policy and procedure guidelines include and the benefits of policy and procedure guidelines. What it includes: policy overview, disputes, dispute resolution, the types of dispute resolution, and how to apply it. The benefits of policy, procedure, and guidelines. It promotes fairness, supports positive workplace relationships, reduces legal costs and risks. What is a dispute resolution? Firstly, what is a dispute? A dispute is a disagreement between two or more parties, and in which the matter remains unsolved between them. Often disputes can be settled quickly and informally in the course of everyday work or small matters of disagreement. However, if parties do not agree on a decision, they will need to resolve the matter in other ways. Therefore, they may need to resolve the disagreement with a more formal approach. Secondly, what is a dispute resolution? Dispute resolution is how disputes are brought to an end, which can occur through different ways, informally and formally. Dispute resolution methods. There is two different methods of dispute resolution, formal and informal. Before deciding on which method is best suited for the situation, we need to understand both methods. Formal resolution is a method which involves organized processes and frequently comply with rules and guidelines set by legal systems such as the law or institutions. It usually requires the guidelines to be followed and documented. Formal dispute resolution methods are mediation, arbitration, and litigation. What is mediation? A neutrally third party who helps the involved parties reach a mutually acceptable solution with their disagreement. Mediation is often organized through legal or organizational processes. Advantage of mediation is that it is less expensive, quicker, and a more collaborative approach. Although mediation seems like a great option, it cannot always ensure the outcome is favorable to both parties. What is arbitration? Arbitration is a similar whilst also different to mediation, as a neutrally third party makes a binding decision based on the evidence and agreements presented by both parties with disagreements, which is a more formal process than mediation and often involves legal procedures. An advantage of arbitration is that it's efficient and flexible, which results to quicker resolution of disputes. A disadvantage of arbitration is that resolution can be unfair. What is litigation? Litigation is another formal dispute resolution method which involves resolving disputes through the court system, which can be complex and really costly, but it is essential for protecting the rights and interests of a party within a conflict. An advantage is appearing in court will remain. An advantage of litigation is when appearing in court, which will mean a public record of the dispute can be held, which can be advantageous. A disadvantage of litigation is that it's really time consuming. Informal dispute resolution methods. Informal resolution uses direct communication between parties, which is less structured than formal methods, which offers flexibility and speed in resolving issues. Types of informal dispute resolution is negotiable and informal mediation. Negotiation. What is negotiation? Negotiation is direct communication with parties who are involved in a dispute to reach a mutually acceptable resolution. This method can be proposed into everyday workplace disputes. An advantage of negotiation is that it will save trouble and money, and also time. A disadvantage of negotiation is that not all issues are negotiable, as many disputes will need certain procedures to be resolved. Informal mediation. Informal mediation is when a third party, such as a manager, colleague, or anyone in the workplace who helps facilitate conversations, resolving in most cases everyday work disputes between parties without formal procedures. An advantage of informal mediation is that it's quick and really cheap. A disadvantage of informal mediation is that it lacks formality and disputes may not always be fully resolved. Disputes. Disputes can occur between all stakeholders, such as employees, clients, subcontractors, etc., which can be resolved formally or informally. For example, while managing a construction project, and when you've hired a subcontractor to handle such as electrical work, plumbing work, concreting work, anything, midway through the project, there's a dispute between the subcontractor as the work isn't meeting the quality standards specified in the contract. And this will concern all construction managers about delays and potential costs. Therefore, with the use of mediation process, with the use of mediation process, which results in subcontractors agreeing to redo substandard electrical work, plumbing work, concreting work at their own cost. The mediation also includes a revised schedule to prevent project delays, and the revised work meets the quality standards and the project progresses without additional legal disputes. Thank you for listening, and I would love to hear your feedback. Thank you.